Hey guys, today we're going to talk about the other elements of the tort of inducing breach of contract. The third element for this tort of inducing breach of contract is direct persuasion or inducement. Persuasion can be peaceful attempts to induce the contract breaker to break his contract. And persuasion and inducement can also take the form of bribes, bounties, or even threats. Such persuasion must be direct at the contract breaker and have the effect of influencing him to break his contract. When the contract breaker is a company, there has to be direct inducement. Direct inducement has to be directed at the managing director of the company or the alter ego of the company, in other words, the controller, the main owner of the company. If the persuasion or inducement is directed to the employees of the company, then it will not be satisfied. This distinction is important because in the case of company, liability for inducing breach of contract will only arise where there is direct persuasion or direct inducement. Therefore, it has to be directed at the managing director or the alter ego. The Singapore High Court in the case of Abani Trading and PT Delta Carina found the defendant liable for inducing the breach of contract. They found the defendant liable from the surrounding circumstances and the acts of the defendant. The High Court also mentioned in passing that it is not always necessary to introduce evidence to show persuasion or procurement because relevant circumstantial evidence may constitute sufficient proof for proving this tort. Sometimes the defendant may be found liable for inducing breach of contract even without direct interference with the contract. In the English case of British Motor Trade Association and Salvadori, the association entered into contracts with buyers of new cars. The contracts contain a clause and undertaking that the buyers of the new cars will not resell the cars to other party. So Salvadori, knowing full well of these contracts containing the undertaking, then bought the cars from the buyers. The Chancery Division of the High Court of England found that Salvadori was liable even though he did not directly interfere with the contracts. What this means is that a person can commit a tort even if what he does is no more than agreeing to a transaction which he knew to be inconsistent with the contract breaker's other obligations. So this is called inconsistent dealing. So you know there's a contract, even though you don't directly interfere with the contract, you do something inconsistent with the contract breaker's obligations under the contract. This case has been widely criticized and the principles in this case has not yet been applied to Singapore. So Singapore may decide to depart from this position, this very strict position. The fourth element for the tort of inducing a breach of contract is there has to be a breach of the contract. Liability under the tort only arises where the defendant's inducement and persuasion results in actual breach of the contract of a primary or secondary contractual obligation. What is primary obligation? For example, in a sale and purchase agreement for shares, the primary obligation would be to sell the shares. If there is a clause in the share sale contract stating that in the event of default in not transferring the shares, liquidated damages of $100,000 will be payable. That is a secondary obligation. So to recap, the inducement has to result in the breach of a primary or a secondary obligation. It follows from this reasoning that there will be no liability on the defendant if the contract was not breached or the contract was void on the grounds of incapacity or illegality or some other reason. The fifth element that the plaintiff must prove is that he suffered damage as a result of the breach of the contract. In the English case of Jones Brothers and Stevens, the defendant, the person getting sued, employed the plaintiff's servant and continued to employ him even when he found out that and he knew that the servant broke the contract with the plaintiff. The court found that the defendant was not liable in tort for inducing the breach of contract because the servant would not in any event have returned to work for the plaintiff, and therefore the plaintiff did not sustain any damage as a result of the defendant's inducement. The damages recoverable for this tort include all intended damage, as well as damages that are not too remote. The plaintiff does not need to prove particular damage because the damage will be inferred from the circumstances of the breach. The damages will be inferred from the circumstances if the breach were of such a nature that it would in the ordinary course of events inflict injury on an innocent party. Let me give you an example. There is an agreement between A and B whereby A agreed to buy $1 million worth of goods from B. I, knowing that A and B have this sale and purchase agreement for certain goods, offer A to buy the goods at a discount, $700,000. So I'm inducing A to break his contract with B by offering him a lower price, inducing him with the lower price, the discounted price, to break his contract with B. So the damage that B would suffer under these circumstances would be the loss of the revenue of $1 million. So if B sues me for inducing the breach of the contract between A and B, the damages would be $1 million, but the amount of $1 million in damages may be reduced because of this concept of mitigation of damages. So thanks for watching this second video on the tort of inducing breach of contract.